Good afternoon and welcome colleagues, invited guests, members of the general public who are following today's proceedings of the Standing Senate Committee on Legal and Constitutional Affairs. Today we continue our consideration of Bill C-16, an act to amend the Canadian Human Rights Act and the Criminal Code. With this our last day of hearings on the bill. We will move to clause-by-clause consideration tomorrow. With us today for the first hour are Jordan B. Peterson, Professor, Psychology Department of the University of Toronto, and from the D. Jared Brown Professional Corporation, D. Jared Brown, Lead Counsel. Thank you, gentlemen, for being here. You both have up to 5 minutes for opening statements, and Mr. Peterson, I believe you're going to lead off, Professor. The floor is yours.
So I think the first thing I'd like to bring up is that it's not obvious when considering a matter of this sort what level of analysis is appropriate. If you're reading any given document, you can look at the words or the phrases or the sentences or the complete document, or you can look at the broader context within which it is likely to be interpreted. And when I first encountered Bill C-16 and its surrounding policies, it seemed to me that the appropriate level of analysis was to look at the context of interpretation surrounding the bill, which is what I did when I went and scoured the Ontario Human Rights Commission web pages and examined its policies. I did that because at that point the Department of Justice had clearly indicated on their website in a link that was later taken down that Bill C-16 would be interpreted within the policy precedents already established by the Ontario Human Rights Commission. So when I looked on the website, I thought, well, there's broader issues at stake here, and I tried to outline some of those broader issues in the initial. You may or may not know, I made some videos criticizing Bill C-16 and a number of its of the policies that surrounding it. And I think the most egregious elements of the policies are that it requires compelled speech. The Ontario Human Rights Commission explicitly states that refusing to refer to a person by their self-identified name and proper personal pronoun, which is the pronouns that I was objecting to, can be interpreted as harassment, and so that's explicitly defined in the relevant policies. So I think that's appalling, first of all, because there hasn't been a piece of legislation that requires Canadians to utter a particular form of address that has particular ideological implications before, and I think that it's a line that we shouldn't cross. Then I think that the definition of identity that's enshrined in the surrounding policies is ill-defined and poorly thought through and also incorrect. It's incorrect in that identity is not and will never be something that people define subjectively, because your identity is something that you actually have to act out in the world as a set of procedural tools, which most people learn, and I'm being technical about this, between the ages of 2 and 4. It's a fundamental human reality. It's well recognized by the relevant, say, developmental psychological authorities. And so the idea that identity is something that you define purely subjectively is an idea without status as far as I'm concerned. I also think it's unbelievably dangerous for us to move towards representing a social constructionist view of identity in our legal system. The social constructionist view insists that human identity is nothing but a consequence of socialization, and there's an inordinate amount of scientific evidence suggesting that that happens to not be the case. And so the reason that this is being instantiated into law is because the people who are promoting that sort of perspective, or at least in part because the people who are promoting that sort of perspective know perfectly well that they've lost the battle completely on scientific grounds. It's implicit in the policies of the Ontario Human Rights Commission that sexual identity, biological sex, gender identity, gender expression, sexual proclivity all vary independently, and that's simply not the case. It's not the case scientifically, it's not the case factually, and it's certainly not something that should be increasingly taught to people in high schools, elementary schools, and junior high schools, which it is, and it is being taught. I included this cartoon character that I find particularly reprehensible, aimed obviously at it as it is at children somewhere around the age of 7. that contains within it the implicit claims as a consequence of its graphic mode of expression, that these elements of identity are first canonical and second independent, and neither of those happen to be the case. I think that the inclusion of gender expression in the bill is something extraordinarily peculiar, given that gender expression is not a group, and that according to the Ontario Human Rights Commission, it deals with things as mundane as how behavior and outward appearance such as dress, hair, makeup, body language, and voice, which now, as far as I can tell, open people to charges of hate crime under Bill C-16 if they dare to criticize the manner of someone's dress, which seems to me to be an entirely voluntary issue. So I think that the Ontario Human Rights Commission's attitude towards vicarious liability is designed specifically to be punitive, in that it makes employers responsible for harassment or discrimination, including the failure to use preferred pronouns. They have vicarious liability for that, whether or not they know it's happening, whether or not the harassment was, and whether or not the harassment was intended or unintended. And so I'll stop with that.
Are you struggling with back taxes or unfiled returns this year? The IRS is actively escalating collections by adding 20,000 new agents. In these challenging times, your best defense is to use Tax Network USA. Along with hiring thousands of new agents and field officers, the IRS has kicked off 2024 by sending over 5 million pay-up letters to those who have unfiled tax returns or balances owed. These guys are not your friends. Don't waive your rights and speak with these agents independently, without backup. Tax Network USA, a trusted tax relief firm, has saved over $1 billion in back taxes for their clients, and they can help you secure the best deal possible. Whether you owe $10,000 or $10 million, they can help. Whether it's business or personal taxes, whether you have the means to pay or are on a fixed income, Tax Network can help resolve your tax burdens once and for all. Seize control of your financial future now, and don't let tax issues overpower you. Contact Tax Network USA for immediate relief and expert guidance. Call 1-800-245-6000 or visit tnusa.com/Peterson. Turn to Tax Network USA and find your path to financial peace of mind. That's tnusa.com/Peterson.
To sum up on the subject of gender, we're going to have government-mandated speech. Now, in opining on the constitutionality of the proposed bill, the Department of Justice said on its website, look, there's a variation to this bill that already exists in most of the provinces. I don't believe that's a robust argument in favor of constitutionality. I would refer you to the comments of the now Chief Justice McLaughlin of the Supreme Court in the decision of Taylor. It's in my brief. The chilling effect of leaving overbroad provisions on the books cannot be ignored. While the chilling effect of human rights legislation is likely to be less significant than that of a criminal prohibition, the vagueness of the law means it may well deter more conduct than can legitimately be targeted. As a lawyer on the ground, I worry about a poorly drafted law and its impact on my clients. As a Canadian, I worry about Parliament tacitly authorizing compelled speech. The brief I provided to the committee contains a comprehensive legal opinion that I published back in December on C-16. There's a table that shows how the federal human rights regime mirrors the Ontario system in terms of enforcement of policies and guidelines.
You'll have to wrap up, sir.
And finally, it includes the case law that underpins the opinion. Thank you.
Okay, thank you both. And we'll begin questions beginning with Deputy Chair Senator Baker.
Thank you, Mr. Chairman, and thank you to the witnesses for their presentation. As the witnesses know, the 9 provinces in Canada have the provision in their laws, including Ontario, and also the words expression, as I recall, appears in 4 or 5 provinces. So what you are arguing is against what we already have in law. Your reference to the criminality, to the sections of the criminal code. At our last meeting, Senator Joyal correctly pointed out that sections 318 and 319 starts off by genocide, under the heading genocide. The next heading is public incitement, likely to lead to a breach of the peace. And you know what a breach of the peace is, Mr. Brown. Willful promotion of hatred. These things are, and then there are defenses listed, as you know, in that criminal code provision. There's several defenses. If you honestly believe in what you said, is if you know, the defenses are extensive in the criminal code. They've worked well for Canada. So what do you have to say about the facts of what's presently in the criminal code and your reflection that somehow the genocide heading, the heading on public incitement, on willful promotion of hatred, somehow that these provisions should not be included under those headings?
I think I have to be clear. My presentation relates to the amendments of the Human Rights Code, or the
And
proposed
not to the
amendment.
criminal code?
And that is, in fact, how one like Dr. Peterson may, in fact, find themselves on the wrong side of jail. And so, if you've reviewed the publication and the opinion, I say that simply by breaching the proposed amendment to the Human Rights Act, and particularly with somebody who is deliberately doing so. For instance, somebody who's saying, I'm not going to use those words. That person, if they are dragged before the tribunal,
The Ontario Tribunal.
or the federal tribunal, I've indicated to you already that the Department of Justice has said they're going to pass the same guideline on pronouns. And so what I'm suggesting to you is that if somebody says, I'm not going to use those words, are brought before the tribunal, the federal tribunal, and the tribunal then delivers an order for a payment of a fine, and alternatively, a non-monetary remedy, i.e. cease and desist order, an order to do something, to compel them to do something. And that person who's brought before the tribunal says, I'm not doing that. They will find themselves in contempt of court, and prison is the likely outcome of that process until they purge the contempt. That's what I'm suggesting. I'm not suggesting to you that that the amendments to the criminal code, well, I'm not advocating genocide, I guess, let's just say that. And my presentation here is restricted to what I see as the pronoun policy issue and the compelled speech issue.
So it covers the provincial legislation that you strongly disagree with, that we've had in place in the provinces for decades in some cases.
It is the policies that were enacted after it left the legislature and which will be enacted after this bill leaves this committee.
I would also like to add to that the fact that once I made the video stating that I wouldn't use the Z and Zer pronouns, for example, which I regard as part of an ideological linguistic vanguard, the university lawyers, after carefully considering what I said, sent me 2 letters to cease and desist in my public utterances because they believed that not only was I violating the university's standards of conduct, but that I was also violating the relevant provisions of the Ontario Human Rights Commission. Therefore, as far as I could tell, vindicating the statement that I made when I made the video to begin with, which was that the act of making the video itself was probably already illegal. And they didn't do that lightly.
Under
So,
provincial law.
yes.
Senator Pratte.
Thank you, Chair, and thank you, gentlemen, both of you, for being here. I have 2 questions, one for Dr. Peterson right at the get-go, and then one for the 2 of you. Hopefully the Chair will indulge me. Deliberations of this bill, and during deliberations of this bill, we keep hearing the term respect thrown around. Respect is indeed critical in debates of legislation as sensitive as this, and there are a lot of people here who need to be reminded that respect works both ways, including people at this committee. Senator Baker has already referred to comments as genocide. I don't think anybody here is promoting genocide. However, Dr. Peterson, can you comment on the notion of respect where some of your critics say, why can you not just respect your students, just use the gender-neutral pronouns? How do you respond to that?
Well, first of all, I'd have to be convinced that doing so would do more good than harm, and I don't believe that. And I think I'm actually in a reasonable position to justify my claim. I think that the danger that's intrinsic to the law far outweighs whatever potential benefit it might produce, especially given that there's no hard evidence whatsoever for any benefit. I would also like to point out that the people who are promoting this legislation claim to be acting on the behalf, say, of the transgendered community, but they weren't not elected nor appointed to act as such representatives and are doing it on their own say-so. I've received many letters, at least 30 now, from transgendered individuals indicating that they are not in accordance with the claims of these so-called representatives to be representing, or with the intent of the legislation, which has actually made them more visible rather than less visible, and the less visible is what they had preferred. With regards to respect, is that you don't meet people, generally speaking, in a mutual display of respect. You generally meet people in a mutual display of alert neutrality, which is the appropriate way to begin an interaction with someone, because respect is something that you earn as a consequence of reciprocal interactions that are dependent on something like reputation, which is also a consequence of repeated interactions. And so the notion that addressing someone by their self-defined self-identity is necessarily an indication of basic human respect for them, I think is an entirely spurious argument, especially given that there's no evidence that moving the language in a compelled manner in this direction is going to have any beneficial effect. We're supposed to assume that just because hypothetically the intent is positive, that the outcome will be positive. And any social scientist worth his or her salt knows perfectly well that that's rarely the case. So,
thank you for being here. I want to quote briefly from a document from the Ontario Human Rights Commission. It says, some people may not know how to determine what pronoun to use. Others may feel uncomfortable using gender-neutral pronouns. Generally, when in doubt, ask a person how they wish to be addressed. Use they if you don't know which pronoun is preferred. Simply referring to their person by their chosen name is always a respectful approach. So you can use a pronoun, you can use their chosen name. So if someone chooses to change his name from Paul to Peter, surely you would use Peter because it's a matter of simple politeness and respect. If the same person chooses to change her name from Paul to Paula, I won't use the name Paula simply as a matter of respect. What's the difference here?
Well, I guess the issue, and speak about the legal issue there, is that you're now introducing the full force of the law behind the requirement to use, and I'm dealing obviously with respect to the pronoun issue. In terms of not addressing somebody by their legally registered name, for instance, I don't think that's where we're running into trouble here. I think the issue becomes that if you don't address somebody by the pronoun that they self-identify by, as I've read out to you, the fact that the full force of the law will be behind that person, that's what I'm finding is troubling in the legislation.
But the Ontario Human Rights Commission gives people the alternative not to use pronouns and use the person's chosen name, which is always a respectful approach. So pronouns are not necessary or not mandatory. You can always choose the person's chosen name as a respectful approach. And therefore, I argue...
I'm not aware that there is a piece of legislation that compels you to use my proper name. In other words, once again, it's the fact that the full force of the law will be behind it when we're dealing with the group being identified in the legislation. And so, for instance, if I were not to call you by your chosen name, I'm not sure you'd enjoy the full force of the law behind you as a result of that. And that's what I'm suggesting to you is the difference here.
I'm just arguing, sir, that you always base whatever you say on what the Ontario Human Rights Commission is saying. And I'm quoting from the Ontario Human Rights Commission document. They're saying we're not mandating pronouns. You can always use the person's chosen name as a respectful approach.
I respectfully disagree. But
then, well, I would say then that's actually an indication of just exactly how poorly the policy documents are written, because I can quote this one, which is also from the Ontario Human Rights Commission website, that says, and I quote, refusing to refer to a person by their self-identified name and proper personal pronoun constitutes gender-based harassment. And so if if the policies were written in a coherent manner and there wasn't internal contradictions, then your statement would be a reasonable objection. But since it's not written that way, and I do believe firmly that that's a testament to the degree to which it's a poorly written set of policies, is that it's full of internal contradictions, and that'll be worked out very painfully within the confines of people's private lives.
Thank you, sir.
Thank you, Senator Batters.
Thanks very much, both of you, for being here. First of all, Dr. Peterson, I want to go back to this issue of personal pronouns, and if you could please tell our committee more about this issue. It's something that I was not at all familiar with prior to this bill being introduced, and in particular about the gender-neutral pronouns and your experience in pushing back against being forced to use those gender-neutral pronouns.
Well, I don't think the people who initiated this legislation ever expected that there would be an absolute explosion of identities, first of all, and also of so-called personal pronouns, as there has been. I think Facebook now recognizes something like 71 separate gender identity categories, each of which in principle is associated with its own set of pronouns. And so it's become, well, linguistically, it's become a parody, essentially. It's become linguistically unmanageable. And it's also the case that words can't be introduced into the language by fiat. I can't even think of a time when that's actually worked. We're not exactly sure how words enter the common parlance, but it's certainly not that way. And so the legislation devolves into a kind of absurdity, as far as I can tell. I mean, one of the people that I discussed this with claimed that the way that you kept track of someone's personal pronouns was to use your cell phone as an adjunct to your communication. And I mean, you wouldn't say anything like that if you knew anything about common human nature, let's say, and the manner in which people communicate with one another.
Okay, so the types of pronouns you're talking about, just so everyone's clear, because I don't think these are common parlance, Z and Zer, and what other sorts of gender-neutral pronouns are we discussing here?
Well, I have a very bad memory for that sort of thing, but if you're interested in it, you can find lists of them very rapidly on the web, and they've been produced by, I think, people whose essential desire is to gain linguistic control. That's as simply as I can put it, is to gain linguistic control. But they're not used popularly. And that seems to me to be it's a real problem as a consequence, that you make failure to make their use something that could carry a criminal penalty. So I just don't understand that. And I don't understand how the government can justify imposing a criminal penalty on the use of words that no one either knows or uses. It just seems preposterous to me. But there it is.
Could you please also tell us a little bit more about your personal experience in pushing back against this? And I mean, many are familiar with your story, but not everyone, so I just want to give you a little
Well, I made a video, actually I made 3 videos, but we'll just talk about one of them. I made one criticizing Bill C-16 for the reasons that I already described, because I went and read the policies, and they made my hair stand on end to the surrounding policies. And so I made a video stating essentially that and detailed out my reasons. And I've been following the battle of, let's say, ideologies on campus for a very long period of time, and I suppose I have some expertise in that. And there's an ideological war that's ripping the campuses apart, and it's essentially between an ideological variant that's rooted in what's come to be known as postmodernism, with kind of a neo-Marxist base, and modernism, I would say. And that's accounting for all the turmoil on the campuses, and I see this as an extension of this campus turmoil into the broader world, and I really believe that is the proper level of analysis. I truly believe that. And so I said that I believe that this is a vanguard issue in a kind of ideological war, and that I'm not going to participate on the side of the people whose ideological stance I find reprehensible, unforgivable and reprehensible, especially the Marxist element of it. And so I announced that I wasn't going to use these words because I don't believe that they're instantiated to protect anyone's rights. I believe that the ideologues who are pushing this movement are using unsuspecting and sometimes complicit members of the so-called transgender community to push their ideological vanguard forward, and I firmly believe that. So I'm not participating in that. And the fact that it's potentially illegal for me not to participate in that is something that I regard as, I think that's absolutely dreadful. It puts a shudder in my heart as a Canadian that we could even possibly be in a situation like that. You know, if the identity claims that are instantiated in this in the policy surrounding this legislation are applied, it's going to be hell for the psychiatrists, excuse my language. It's going to be very difficult for the biologists and the psychiatrists next. And I think we'll see that happening very soon.